Hi there, my name is Jane Wesley Brooks. I'm with JWB Family Law in San Diego, California, and welcome to Tuesday's Tips. Today's topic is, what do you do when you are served with a restraining order? That's a very serious problem to have. First of all, you may have been served the restraining order by the Sheriff's Department. Most likely you are served by the Sheriff's Department, and if the restraining order has a kick-out order with it, the sheriffs will make sure that you are escorted from your home that you share with the now protected party. When this happens, you must not ever contact the protected party, directly or indirectly. What does that mean? You do not call them, you do not text them, you do not email them directly, nor do you ask anyone else to call, text, or email them to communicate in any way. You are now a restrained party by court order. If you attempt to contact them directly or indirectly, you will be in violation of the restraining order. And at the date on the front page of the restraining order, there is a date that you have to go to court. If you go to court on that date and you violated the restraining order, I guarantee you that's the first thing that the other side, whether they are by themselves or with an attorney, is going to notify the court that you violated the restraining order. And a violation of a restraining order shows that you do not have any impulse control, and it also shows that you are willingly violating a court order. So once you are served, that's it, no more contact. Also, once you are served, you need to read all the documents that were served to you. You need to read what they are alleging happened, what incident happened between you and the protected party that prompted them to file a restraining order. And when you read it, go through line by line and indicate if you believe that that's a fair assessment, or if you don't, why not? And what do you have to show that what the protected party is alleging is not true? You may want to contact a family law attorney who has experience and skill in defending domestic violence temporary restraining orders. It is especially important that you contact an attorney if there are children involved. If you have children with the protected party, and if there is any claim that the parties and their children were present during whatever the underlying incident is that, got them to get a restraining order, it is very important that you talk to a family law attorney, because if their story is credible and they have witnesses or audio recordings or video recordings or whatever, and they say that the children were present, you now stand to lose custody of your children under Family Code Section 3044. The other thing that's very important is that in domestic violence temporary restraining orders, the party who is the prevailing party, if they win the restraining order hearing, they can ask that the other party pay the fees. So there's a lot at stake here. Most importantly, your children, if you have children with that other party, your own sense of self is at risk when somebody accuses you of something like domestic violence. So your own sense of self and reputation is at risk. And there's a financial component. You may end up paying a lot of attorney's fees if you lose at the hearing. So it's worth it to you to have a family law attorney look at your case and assess what is in your best interest in terms of moving forward. At JWB Family Law, we do offer a complimentary 30-minute consultation. If you have been served a restraining order, I strongly suggest that you contact a competent family law attorney to assist you in your response. I wish you the best of luck.